Hi guys, can you all see me? Alright, good afternoon. This is Natalie. As most of you all probably know, I'm the latest addition in MECA, replacing Victor mainly. So for today's session, I'll be covering on one of the most interesting yet crucial area, which is on the issue of employment of women. Alright. Now, of course, before I start on the legal aspect of this area, let's go down to some statistics in terms of um, how does employers view how substantial is female employees in their workforce. All right. Okay, now according to the statistics derived from Talent Corp Malaysia, um, our enrollment in terms of female in the local university comprises about 60%. However, out of this 60%, only 46% make it to the labor force here in Malaysia, and this figure actually dwindles according to the hierarchy of position. Now, the higher the level you go, the number and percentage simply just decreases. Okay. Now, let's make some comparison with our closest neighbor here. If we look at Thailand, they have about 70% of their labor force comprises of women. And in terms of Singapore, it only takes about 60%. Now, I would not, or rather, compare ourselves with Thailand. Singapore is way ahead of us, developed and so forth. So let's compare between Malaysia and Thailand. Um, 46% of labor force, 70%. How does that justify? Is our females here in Malaysia less smarter compared to those people in Thailand? I don't know, but something doesn't seem to gel well. Um, yeah, but this is what the statistic shows. Yeah, moving on. Now I have some case study here, which I of course derive from Talent Corp Malaysia, where the source of this information comes from. Now where this statistic simply shows that in terms of one of the most successful company that has deployed substantial workforce of this particular organization comprises of female is Diageo Clef in Scotland. Whereas the nature of the business is, of course, they are the world's largest collection of whiskey. It is a global brand, has an excellent track record of female leadership. You can probably read from my slides, in one of the best performing companies on the FTSE 100, recognized for the culture, diversity, and financial performance. And this is further, of course, reflected in their non-executive board. Now, this is what the current position of um, this company now, as in this company that go claim in Scotland. However, if you just to look back a decade ago, there's just one woman out of 10 who sits in the non-executive board. However, today there's four women out of the board of 11, bringing a total of 36%, with background in finance, marketing, government, and management consultancy. Moving forward, now what is happening here in Malaysia? Now we are all working here in Malaysia. Of course, we are curious to know. We have seen statistics of other countries, how successful females being on the board of directors. Scotland would be the best example to show that. But here in Malaysia now, it's obvious from the statistics derived that there is a low labor participation rate of women, and the reason varies. Firstly, perhaps to raise a family, female, the maternal instinct, taking care of their child. Um, at the same time, some of them has elderly parents, so they take a step back from their career and to take care of a sick family member. Could be their mom, could be their dad, you know. And this is quite a worrying figure because Malaysian workforce seems to be losing these women as they get to the middle management with only 11% remaining in the workforce. Now, if we look in terms of our earlier slide shows that 46% of them are actually in the university. So, 46 to 11, that's quite a big jump, dwindling figure, and it should be worrying. Now, so what does all these women want? How can employers, the companies here in Malaysia attract these women to join the workforce and increases together with the ladder that they climb? Okay. Firstly, the statistics again shows that these women actually want flexible work arrangement that can accommodate their family commitments. Flexible arrangement, perhaps, work from home, you are more relaxed in times in terms of taking leave, there's only 30% of employees here in Malaysia that accommodates to that. Secondly, they also look in terms of facility policy for mothers at work. Some companies do provide childcare facility, and this, but here in Malaysia, it's obvious that the statistics only shows there's only 7% of the employees here that does so. Childcare policy could be things like a breastfeeding room, or some of the companies which I've personally visited that they actually have a playroom for the kids to come after school. Um, Thirdly, of course, what a female employee can do, a male employee could do as well. So we are of course fighting for equal opportunities. Okay, this view might be a bit biased coming from women myself. Okay, however, having all these 3 points, employers are more likely to retain and attract women talent. Um, this is what the statistics shows, and perhaps moving forward, this is now beginning of the year, the HR managers might want to introduce certain policies to the company. This is the best time of the year in terms of, I'm sure some of the companies, you are giving out the increment letter, increment salary letter. This is the best time of the year to review your policies in your handbook. Okay, so today, for today's session, I'll be covering 3 areas in terms of employment of women. I've been getting a lot of inquiry in regards to maternity protection. So these will be our main key area that I'll address today. However, if the time permits, which is also included in my slide actually, if I didn't manage to finish it all, as you can probably see, I have about 31 slides to go through, and we only have 1 hour session. The 2 other less popular area, but somehow they do crop up from time to time, the employment of women at night. What kind of industries that allows women to work at night? There's a quite big to discuss there as well. And of course, employment of women in terms of underground. So yeah, those are the 2 minor areas that I'll try to cover if I can, but if not, you can just read from the slides. So let's start now, maternity protection. Now, of course, when you talk about maternity protection, we look at what is the scope of this maternity protection and what is the application like. Now, Section 44A technically states about application of maternity protection is for all female employees. Well, it basically states that the whole, if I could read it to you, the whole of this part of maternity protection is applicable to every female employee engaged under a contract of service, irrespective of her wages. Now, what does this mean? You see, we all know that the Employment Act mainly covers regards to employees who are earning below 2,000 ringgit, and of course those who falls within the exception of first schedule para 2 sub 1. If you go for under any of those limbs, of course you're automatically covered under the Employment Act. However, there's certain areas like maternity protection, sexual harassment, it covers across the board. regardless of whatever wages that is earned by that particular female employee, um, they, these two scope on maternity protection as well as sexual harassment will automatically cover her as well. Okay, so I can explain that. So executive managers earning more than 2,000, yes, you're definitely covered under the maternity protection area. All right. Now moving on. So who is eligible to apply for maternity protection? Must you be married in order for you to be eligible for this particular, for you to fall under this particular protection? Now, Section 37(1)(a) is pretty interesting. Now, if you look at the wording of Section 37(1)(a), it basically states that every female employee is entitled to maternity leave for an eligible period in respect of each confinement, regardless whether or not she is married. So I'd like to first tackle the area regards to whether or not she's married. As you can see, I underlined the word there, married. So if at all a woman has a child out of wedlock, that's one, could be one of the areas, or she's a rape victim, but she still wants to carry the child. Section 37 sub 1 sub A basically says that she'll be eligible for a maternity leave. That's the first leave. And then you need to also go on to see that what is defined as confinement. But before we even go on to the word confinement, definition of confinement per se, the word married. So like I said, if you have a child out of wedlock or you're a rape victim and you still want to carry a baby, meaning you go through the period of confinement more than 22 weeks, then you are automatically eligible for the maternity leave, which is 60 days. I'll address these issues later, of course. Okay, that's one issue that we are looking at. Now, so the definition of confinement. Now, confinement is defined as the process of giving birth after 22 weeks of pregnancy. The previous provision basically stay was 28, but it's now been revised to 22 weeks. Now, you must be aware that a confinement doesn't mean that it must be a process of giving birth after 22 weeks. It could also amount to situation where if there's a miscarriage that took place after 22 weeks of pregnancy. That's one situation. Or the birth results in more than one child. So for example, at her first confinement, she had twins, triplets, or quadruplets. Okay. Of course, she's still entitled to this maternity leave. Okay. Then finally, the third situation covers the area of the child. If she gives birth to a child which is stillborn, or the child is dead and so forth, then of course definitely she would still be eligible according to Section 37(1)(a). She'll be eligible for maternity leave. Okay. Now moving forward, of course you like to hear in terms of whether does confinement automatically attract maternity leave with pay. Now, there's of course a distinction you need to know: maternity leave with pay and maternity leave without pay. At this juncture, I will address the issue of whether confinement automatically attracts maternity leave with pay. Subsequently, somewhere in the slides towards the end, I will address the issue, in terms of maternity leave without pay. All right. Now, firstly, yes, confinement automatically attracts maternity leave with pay, provided that the conditions stipulated in these two provisions, Section 37 sub 1 sub C and 37 to A, are satisfied. Now, of course, you are now asking what is Section 37 sub 1 about and Section 37 sub 2. Okay, I will explain it to you. Now, let's look at some situations. Section 37 sub 1 says that it actually limits on the number of children for entitlement to paid maternity leave. So for example, if you have a female employee, Devi, who is at the time of her confinement has 5 or more surviving children, she will not be eligible for paid maternity leave. Section 37 sub 1C simply says that if you have more than 5 children, then you will not be eligible. I hope you're following what I'm saying. It's pretty easy to say. 5 or more, you're not eligible for paid maternity leave. We look at the second situation. Let's say now you have another female employee, Belinda, who is at her first confinement, had quintuplets, meaning 5, and all of them are surviving. Now, she would not be eligible for any paid maternity leave in terms of her future confinement. Okay. Now let's move on and complicate the situation a bit further. So now you have Angelina Jolie, as we all know, famous for adopting children from all around the world. Okay, so Angelina Jolie now have 3 adopted children, and on top of that, say she has 2 stepchildren, and all 5 of them are surviving. And at the same time, she's now at her first confinement. Now, we need to look at what is the definition of children. See, she would be entitled here, in this situation here, she would be entitled to paid maternity leave simply because children are defined under the Act as children, as natural children. So as such, adopted children, stepchildren are irrelevant in determining whether or not she has 5 or more children. So her quota is still there. Okay, she's only at her first confinement. So if you say after 22 weeks, she gives birth to a child, to a baby. So she still have 4 more to go. Alright. Now moving on. Okay, let's twist this situation a bit further. Say you now have 7. 7 now is at a 6th confinement. Alright. Now as a 6th confinement, prior to this she has 4 surviving children within the age of 18 to 23 years old. At the same time, she also have on top of these 4 surviving children, she has another child, age 21, who has recently passed away due to leukemia. Now, before determining whether she's eligible for paid maternity leave, you must first know that children are defined as natural children, as how I shared with you earlier, and the age is irrelevant. They could be as young as 1 year old, or they could be as old as 30, 40 years old. The age is simply immaterial in determining so. Now, the situation here is she has 4 surviving children during her 6th confinement. Then she will therefore be eligible for paid maternity leave. You see, the Act Section 37 sub 1 sub C says 5 is the quota. So she has 4 surviving child, now she's at 6th confinement, and she has 1 dead child, so 5 in total. Yes, therefore she'll be eligible for paid maternity leave. Okay. Moving on. Now, what if I've heard situations where some of the HR managers actually call me and say that, look, we care about our female employees. We would like to give an added benefit. We support the idea of procreation. So it's okay, even though a female employee have 5 surviving child and she's now on the confinement of the 6th child. Can we give a more favorable benefit, as in to still give a paid maternity leave? Can the company do so? Now, if you look at Section 7, capital A under the Employment Act, and Section 7 states that nothing prevents an employer or an employee from agreeing to a more favorable provisions rather than adhering to those provisions under the Act. However, because of the express provision by the words shall not be entitled as stated under section 37 sub 1c, which governs the maternity leaves, therefore section 7 capital A does not permit the employer to grant a more favorable benefit under section 37 sub 1 sub c. Hence, the company cannot do so because of the wordings of the words. All right. Moving on. So let's change the situation a bit. Now we are looking at the provision of section 37 sub 1 double A. All right. Right of female employee on unpaid maternity leave to return to work early. You see, if you have, say, we have an employee, Siti Nur Haslina, who has 5 surviving children and is now on her 6th confinement, she would have to take unpaid maternity leave as she has 5 or more surviving children at the time of this confinement. This is what stated under section 37 sub 1 sub c. On her 6th confinement, she can't take any more paid maternity leave. There's no more, her quota is finished, in other words. So what can she do? Can Siti Nur Haslina opt to return to work earlier than her eligible period? Now, yes, you can actually do so in order for her to earn her wages, because she, on her 6th confinement, she will be on unpaid maternity leave. However, there's 2 things that you must look into. Firstly, the company must consent, and secondly, she has been certified fit to resume to work by a registered medical practitioner and not some Bomo or some Chinese traditional healer. I've been hearing cases in the past saying that, oh, the midwife say I can come back to work. I like to come back to work. It's in this situation, it cannot, because the Act clearly says that it must be a registered medical practitioner. Okay. Now I do see some questions popping up in the chat area, but yes, I'll be able to send a presentation after the session. In terms of question about daycare center for kids in the company, Manu, maybe you want to elaborate a bit further. I'll try to come back to you after this session, because you have to take time to answer your queries now. I might not be able to finish up the slides. Alright. So Ibrahim, yes, I see a question from you. Is there any consequences to the company for offering more favorable maternity benefits for more than 5 surviving children? I think I've just addressed this. You can look through back the slide and take a look at it. Alright. Now moving forward with the presentation for the day. Now, as I mentioned earlier in my presentation, in order for a female employee to be entitled to a paid maternity leave, she must satisfy 2 conditions. And this condition is stipulated under section 37 sub 2 paragraph A, which states that what are the conditions for entitlement to paid maternity leave. Now, firstly, she must have been employed by the employer for at least 90 days during the pregnancy period, and she must have been in employment with that employer at any time during the 4 months preceding the confinement. So what does this mean? What does this connote? Okay, I'm sure you are clear about the part that at least 90 days is pretty straightforward, but the phrase at any time during the 4 months immediately preceding the confinement. This means that if she was in employment for even 1 day during the last 4 months of her pregnancy, she will satisfy this condition. Now, please absorb this a bit further and bear these two criteria in mind. Because what we're going to do next is that I'm going to show you some permutations, some situations, and we'll try to apply what we know about this particular provision. All right. Okay, the first permutation. Say for example, Alice resigned on the 1st September after working 2 years with the company, and then she subsequently gave birth on 1st December. So the question here is, of course, does she satisfy the two conditions under section 37 sub 2 sub A? Now, the first criteria, as I mentioned earlier, she must have been employed by the employer for at least 90 days during the pregnancy period, and she must have been in employment with that particular employer at any time during the 4 months immediately preceding the confinement. Here, since Alice resigned on 1st September, she would satisfy the criteria under section 37 sub 2 sub A that she has been in employment for more than 90 days during the pregnancy period, which is from March to November. That's one. Two, she was also in employment during the 4 months preceding before her confinement, which is from the month of August till November. Okay, do you follow me so far? I hope you do. If you can't, after the session, feel free to give me a call, drop me an email. I will try to explain to you a little bit further. All right. Moving on to the second permutation. Sorry, before we even move on to second permutation, yeah, I need to explain to you if at all therefore, as of any situation, she'll be entitled, subject to section 40 sub 1, which is a provision that you need to satisfy, to go back to a former employer and claim her maternity allowance when she's no longer in employment with that employer. Now you will be now wondering, she has resigned on, if you look at the facts again, she has resigned on the 1st of September. And assuming now she has moved on to a new company, all right? And her maternity leave was taken when she was, of course, in the new organization. Now, how does it make sense that Alice will now be entitled to maternity allowance when she's no longer in employment with that employer? The employer here means the former employer. Now, this is because she satisfied the two qualifying conditions under section 37 sub 2 paragraph A, and further can also be seen from section 40 sub 1 and section 37 sub 3 that she's entitled. And what does these two sections entail? I'll explain to you this shortly, but I hope you are following again so far. That Alice, let me just make a quick recap. Alice will be entitled, subject to section 40 sub 1, to go back to her former employer and claim a maternity allowance, even though she's no longer in employment with that particular former employer. Okay. Now, I'm going to move on to a different permutation now, but of course I'll address Alice's issue shortly in the next coming slides. Okay, Brenda here commenced her employment on the 10th of September and subsequently gave birth on 1st December. Again, the question that you always need to ask yourself whenever you face with this kind of situation, whether does she satisfy the two conditions under section 37 sub 2 para A. Firstly, she must have been employed by the employer for at least 90 days during the pregnancy period, and she must have been in employment with that employer at any time during the 4 months immediately preceding the confinement. Here, since Brenda commenced her employment on the 10th of September, although she would satisfy the condition, the second condition, which is she has been in employment with that employer at any time during the 4 months immediately preceding the confinement, Brenda would not be able to satisfy the condition in the first condition, as if you to do an exact calculation here, 10 September to 1st December, there's only 82 days there. She's only been in employment for 82 days. The condition in the first condition states that she must be in employment for at least 90 days. Okay, therefore, she will not be entitled to paid maternity leave, but she's of course entitled to unpaid maternity leave. Alright, moving on. Now, is it possible, like I mentioned earlier, I'll address the issue about Section 37 sub 3, the effect of satisfying the qualifying conditions for paid maternity leave with two employers. Remember the situation earlier with Alice? Now, is it possible for a situation to arise where a female employee is entitled to claim maternity allowance, like Alice's situation, from two employers? Now, Cecilia here, a new character, resigned from company ABC on the 1st of September and joined company XYZ on the 2nd of September. She subsequently delivered her child, her baby, on the 10th of December. Now, Cecilia here would definitely have a 90 days of service with both employers during the pregnancy period, and hence she would also at the same time be in both employment for at least 1 day during the 4 months before her confinement. Now, okay, I'm sure some of you all are now jumping joy saying that, okay, so she was working with both employers during a pregnancy period of 90 days of service with both. She will also satisfy the criteria of 4 months before confinement because she's been in employment for at least 1 day with each of them, with each of the employer. Can I make a double claim now? What do you think? I will move on to the next slide, of course, to explain this. Now, the law is very clear on this area, saying that when there is more than one employer from whom the female employee is entitled to claim for a maternity allowance, she can only claim from the current employer. I mean, in other words, she can only claim from the one that she's currently working with, not the former employer, in terms of maternity allowance. But if I'm the current employer now, I'll say, look, this isn't fair. She's only with us she's only with us for a short duration period of time, and she was also during her period of confinement. She was also with the other former company. Is there any way I could prorate the maternity allowance? In other words, what other recourse does the current employer have since the former employer did benefit from the services of this particular female employee? Now, you could actually, as a current employer, you could actually recover those monies owed, those maternity allowance from the former employer, but you need to go through, you need to cover it via the way of civil debt. Civil debt here means you go to the civil jurisdiction of the court, depends on the amount. It could probably be in session court, I suppose. Session court amounts is from 100,000 to 1 million. So you file a claim for civil debt in a civil jurisdiction court to recover these debts. Okay, and let's like I shared with you earlier, you need to take note that the current employer is not prevented from recovering the proportionate payment from the former employer, even if the female employee had failed to notify her former employer that she expects to be confined within the next 4 months, as stated in section 40 sub 1. What does this mean? For example, this particular female employee, I think it's quite clear, failed to inform her former employer that she's going to deliver a baby. She expect to deliver a baby within the next 4 months as per section 40 sub 1. It does not stop you being the current employer to recover the proportionate payment from the former employer. Do you follow me so far? I mean, I hope you do. Like I said again and again, if you can't, feel free to drop me a line or my email or give me a call at our office, and I should be able to explain to you further if you have areas that you're a bit confused, or my explanation is not clear, or you probably have a similar situation, but perhaps some of the facts of the case is slightly different from the situation that I've posed up here. Please speak to me more. I should be able to help you if I can. All right. Moving on. Now, I'm addressing the area on section 40 sub 4 in terms of the effect of a pregnant female employee refusing free medical treatment provided by the employer. So, in situation where an employer provides free medical treatment to his employee, and this particular pregnant female employee persistently refuses such free medical treatment that is certified by a doctor to be necessary in connection with the pregnancy. So, for example, that this particular female employee said, I'm having a difficult pregnancy, but the company is giving her some free medical treatment, and she said no, I don't want to. I do not want to receive this benefit. Then the employer can forfeit the female employee's entitlement to maternity leave pay for up to 7 days period. Okay. Now, I'll give you an example here. Deirdre, for example, she's always on sick leave during her last month of pregnancy. She's refusing to take medical treatment prescribed to her, as she prefers traditional treatment. In such a situation, Deirdre now forfeits her entitlement to maternity leave pay for up to 7 days, and therefore, as you all know, maternity leave pay is for 60 days. Here, since the 7 days are forfeited, hence she will only be eligible for 53 days of maternity leave. Alright. Of course, I'd like to clarify a bit further in terms of traditional treatment here. I'm referring to, again, some Chinese herbal healer, Bomo, I'm sure you guys are pretty clear what is traditional treatment, alright? So, yep, if at all an employee is providing a free medical treatment to his employee and this employee refuses it, then of course the employee can forfeit the entitlement to maternity leave pay for up to 7 days. So it really depends on the discretion on the Budi Bicara Syarikat on how many days you're going to forfeit. 1 day, but max is 7 days. Alright. Now in terms of section 43, what does it entail? Section 43 basically talks about relinquishing rights to maternity protection is invalid. So what happened here is this, if there is any condition in a contract of service whereby a female employee give up her right to maternity leave provisions provided under the Act is deemed to be void and of no effect. The Act clearly says this. For example, if here company PQR has reached an agreement with AFIDA that she will take a shorter notice period of maternity leave. So she is entitled to 60 days, but she plans to come back earlier. She returned to work, say only after 30 days, she plans to return to work. And she's now also, AFIDA is also now asking that she'll be entitled to be paid extra for the remaining 30 days where she works. Now, of course, the Act says, Section 43 says that this particular agreement between the employee, AFIDA here, with company PQR is invalid, is void, is of no effect, tak sah, in other words. Okay, this is because, and on top of that, yeah, I need to highlight to you that this particular employer, as in company PQR, would also be committing an offence under Section 94 of the Act, where it carries some form of penalty. Take a look at the Act, Section 94. It's there. All right. So do take note if you have any employees who say that I don't need 60 days. After 30 days, I'm fine. I'm fit. You know, my doctor thinks that I'm fully recovered. They even certify that I'm fit to come back to work, regardless of whatever been said of this employee. And the company said, look, we also need you. You know, it's been 30 days without you, and we have yet to find a replacement to fill in your void. This Section 43 clearly says that the company cannot accept, you know, this employee back to work and pay her the remaining 30 days of you know, untaken her maternity leaves. All right. Moving on. Okay, looks like we have covered the maternity protection area. So looks like I still have some time. So let me run through on the employment of women at night on Section 34 Sub 1. So in regards to employment of women at night, what are the conditions? Now, an employer should not require a female employee to work in any industrial or agricultural undertaking between the time of 10 a.m. and 5 a.m. or commence work for the day without having had a break of 11 consecutive hours. So coming again from the employer perspective, is there any way, any exception for an employer to circumvent this? You can, provided that you, as an employer, you are able to comply with the employment of women, shift for workers regulation 1970, or as an employer, you have been granted an exemption by the Director General of Labour for employment of women at night. But of course, this exemption is subject to the conditions that a Director General may impose. So let's look at what are the conditions that we are talking about here. So when can an employer apply for exemption? Now, an employer can only apply for an exemption if he's unable to comply with the regulations laid down under the section the regulations of 1970. It's quite a mouthful provision, employment of women, shift workers regulation 1970. Only applicable to industrial undertakings approved by the minister for the purpose of these regulations. Okay. Now, what happens to all other unapproved industrial agriculture undertakings that have shift operations? Now, the Director General Labour has issued a general exemption order for employers in Peninsular Malaysia on the 10th of July to permit employers to employ female employees in any industrial or agriculture undertaking between the time of 10 a.m. to 5 p.m. subject to the following conditions. Firstly, the employer, of course, must obtain consent in writing from the employee who are involved in the night work. Secondly, this written consent, of course, you need to be kept at a workplace based on a notice board somewhere that can be seen by the employees involved and shown and should be able to be shown to the labor officer whenever they are asked. Thirdly, the female shift employee must of course be given a rest period of 11 continuous hours before being required to work again. Fourthly, this female shift employee must also be given a weekly rest day which is not less than 30 continuous hours. Fifth, the female shift employee must be paid a shift allowance at a rate that has been agreed upon by both parties. Okay. Now, female shift employee are not permitted to work in. This is the sixth condition that you need to comply as employer. A female shift employee are not permitted to work in the night shift on a permanent basis. Emphasize here the word permanent basis for a period exceeding 1 month, and they should be given an opportunity to work the morning or afternoon or night shift on a rotation basis. Um, Seventh provision states that a female shift employee must also be provided with free transport to and from work. In other words, those baskilang, yep, free transport, that's what he meant. The employer should also pay particular attention to the welfare and safety of the female employees who work in the night shift. Now, the number of crime rates has been increasing of late in terms of welfare and safety. Of course, make sure that the area where this particular employee is working is properly lighted up. Things like that, welfare and safety in general. Okay. Now, that's basically about employment of women at night, section 34 sub 1 34 sub 1. Now, moving on to our last area that we'll be covering for the day in terms of prohibition of underground work by women. Now, a female employee is prohibited from any underground working, which is defined under Section 2 of the Employment Act as any undertaking in which the operations pertain to the extraction of substance from below the surface of the earth, for example, mining. So if you're coming from the mining industry, yes, perhaps this section is relevant to you, but more often than not, the it's just there for, of course, for you to use it, but more often than not, yeah, it's these are some smaller sections that most of the HR practitioners are just not aware of. Okay. I suppose we have like 2-3 minutes to go. Um, I'm looking at the chat area here. Let me try to address Ibrahim's question. Now, is there any consequences to the company for offering more favorable maternity benefit for more than 5 surviving children. Now, let's take a look back at my slide. Just bear with me. Now, I think this slide probably answer a question. Um, for example, you want to offer a more favorable benefit for an employee who has more than 5 surviving children. Section 7A, you need to make reference, of course, at Section 7 and Section 7A. Section 7 is, Section 7 states that nothing prevents an employer and employee from agreeing to a more favorable provisions rather than adhering to the provisions under the EA. However, the problem here is that under section, the wording used under section 37 sub 1 sub C, and 37 sub 1 sub C are the governing section in terms of maternity benefits, maternity protection, whatever you want to call it. The words used there, shall is the word here is shall not be entitled. Shall has a very strong force. It's mandatory in terms of, from the legal perspective, the word shall has a mandatory effect. And of course, this is addressed under section 7 capital A, that it does not permit the employer to grant a more favorable benefit under section 37 sub 1 sub C. Okay. Ibrahim, I hope that answered your questions. If not, please drop me a line and I'll be more than happy to assist you to address on this issue. I'm seeing here on Mano asking about daycare center for kids in the company. Yes, I suppose that is one of the way to get more female employees to be in the workforce of your company. I suppose tailors, Mano is from tailors, and coming from tailors, we have tailors is of course a college, and of course yes, beautiful background. Perhaps the management might want to allocate certain provisions to have a daycare center for kids in the company. You can propose that in terms of coming from the HR perspective. You can. Josephine, yes, I'll send across the presentation I mentioned earlier. Now, I'd like to share with you. Today has been quite a tight day for me. I've been getting a lot of issue regards to sexual harassment. Um, Sexual harassment cases. In fact, there's about perhaps 5 companies who called me on sexual harassment issue just for today. I'm not sure what's going on, but it seems that sexual harassment seems to be the hot topic for today. So, in terms of sexual harassment, you need to be aware that if at all there's a claim, there's 2 employees claiming for, as in 2 employees here, what I mean is that colleagues, co-workers, they are claiming that one of them is of course the victim, the other one is the perpetrator. This female employee says like that, okay, I'm not trying to be feminist here, but let's say the perpetrator is of course a male employee. So this female employee complained about it. And lodge a complaint, of course, to the HR manager. Then the best way, of course, to address this issue will be to investigate into this matter. Interview both the perpetrator, interview the victim, get both sides of the story. Because in cases like this, is most of the time is he says and she says. Okay, it's always my words against your words. So hear both sides of the story. Issue a show cause to the perpetrator, put the explanation, and then conduct the necessary DI, and get a panel to decide, whether whether the charge against the perpetrator is valid, whether he's guilty or not. And then after, of course, you can mete out the necessary punishment. If you think the sexual harassment it's just sometimes people do tend to give just remarks, or you're wearing a see-through shirt, for example. Those kind of things sometimes, these co-workers like to just throw these kind of remarks. So you need to be able to gauge whether this particular phrase, I mean, this conversation that took place within this perpetrator and the victim, whether such statement amount to sexual harassment. And this sexual harassment, whether it amounts to sexual harassment, of course, you need to look at the test, how a reasonable woman will perceive this, whether it, see, certain women have um, the level of tolerance is lower. Some people might take it, look, she's just commenting on my shirt, is see-through, there's nothing more to that. But some other people might say that, oh, okay, he's checking out on my body, this is something not right. I feel I'm being sexually harassed. So you need to look at the context of things and when is it being said, what kind of condition, what kind of situation. Um, Hence, the need to conduct the necessary investigation because of that. Okay. This sexual harassment issue has been, of course, addressed in our previous members meeting by Mr. Anupanadurai. So there's slides on this. If at all you're having problems on sexual harassment, to drop me a line, and then we try to get across the slide to you so that you can get a better understanding on this area. Um, yeah, but I think that's all for now. I think I've covered quite extensively on the women workforce. Um, Thank you for listening. I hope you have enjoyed the session as much as I enjoy preparing and delivering to you. Um, I'm running short of time, and Joey and Molly, I will address your concerns over the email. And we have just to update you guys, we're having on the 21st, on 22nd of January, we're having a public course training in JW Marriott. On the 21st, we'll be covering issue regards to retrenchment and VSS. And on the 22nd, we'll be covering areas regards to Personal Data Protection Act, which of course, as we all know, is a hot topic now because the cutoff date given by the government to adhere to the Personal Data Protection Act is 15 February 2014. So those who have not signed up to join us, those who have signed up, I see you there. I will see you there. Just one little favor from me before I close the session. Um, Please, answer the question there, so that I'll be able to gauge the feedback from you guys. How's this session? Um, and it'll be very helpful for me to improve myself moving forward. Yep. So thank you and see you guys soon. Bye. So, I really feel that I'm not sure that it's all. Can you still see me? Hi. So have you guys finished answering the questionnaires? I hope you have. So thank you once again for taking your time to listen to the webinar. Also, yeah, I forgot to mention that our sponsor for this webinar session is by VCube. They are provided from Japan. They have been sponsoring our sessions. So, yep. Thank you for your time, and we'll be in touch with you again. And see you soon. Bye bye.